Welcome back, Crafties. We have some new developments in the Menendez case. Just moments ago, out of LA, a press conference was held with the newly elected district attorney, Nathan Hochman, and he is unofficially recommending that the courts deny the brothers' habeas corpus petition for a new trial. As we know, this is not the first avenue of trying to regain their freedom. However, one of them off the table, unofficially. This press conference today was pretty detailed, so we are going to go through and kind of listen to the best of clips. I was not physically there, so I am going to share some audio clips with you with credit. But the district attorney's office did upload a video explaining what their decision is and why they made their decision. Because we all pay government tax dollars, I feel comfortable posting that video in its entirety. So we're going to take a look at that as well. If you do not feel like going through the press conference with us and that video, no worries, but please engage in the comments section. Let us know what you think. Do you think the Menendez brothers should be free? Clearly, the family thinks they should. And this is nothing new. We are not all of a sudden, because of a Netflix documentary, rallying around them, or are they starting these petitions to be released? This has been an ongoing saga for many years.
Menendezes have raised many of the same exact arguments that they raised in the current habeas petition. Those arguments have been heard by a variety of courts, from the trial judge to the direct appeal Court of Appeals in California Supreme Court, to the California Supreme Court again, to the federal courts. They've considered these arguments, and they have been routinely and repeatedly rejected. So we have the video that is coming out and go through this procedural history so that people can actually learn from the Menendez case and help and actually educate themselves on the criminal justice system. The second thing that we have done today is that we have filed an informal response in connection with the habeas motion. As I mentioned before, there are these three parallel tracks: the habeas, the clemency, the resentencing. Again, the clemency is up to the governor. Resentencing we will be dealing with in the future, in the next coming weeks, with our response. But today we have filed the informal response on the habeas petition. They have basically said there are two new pieces of evidence, along with their arguments, that justify them getting a new trial. Now, in a habeas petition, there are very rigorous requirements to actually get that new trial, which makes sense, because you've already gone through all these different layers of review. And if you've been rejected time and time again, at some point the system says that unless you have something very new and very compelling that is more likely to change the outcome of this case, then we are going to again reject your habeas petition. So when they come out in this case, they come out with two new pieces of evidence. One piece being an undated photocopy of a letter purportedly sent by Erik Menendez to his cousin Andy Cano at approximately December 1988, although there's no date on the letter, in which it discusses sexual abuse that was being experienced by Erik, perpetrated against him by his father at that time. That's the one piece of evidence that they've come forward, but they also came forward with a second piece of allegedly new evidence. The second piece of new evidence was a declaration by Roy Rossello, who basically said that in the early 1980s, he had been sexually abused by Jose Menendez. But the standard to actually have a successful habeas petition requires that you meet all of the following requirements. You have to show that it's new evidence. You have to show that it's timely, that it was evidence that could not be discovered at the time of the trial, but only could be discovered after the trial. You have to show that you did not engage in any substantial delay between the time you learned about the evidence and the time you brought your motion. The evidence has to be admissible, and the evidence has to be credible. Now, the overall argument about this new evidence, again, new evidence effectively dealing with sexual abuse that Erik Menendez experienced by his father, or a gentleman named Roy Rossello experienced by Jose Menendez, the defense has now argued the following. They've said to resolve this case, jurors had to decide a single critical question. Was Jose Menendez molesting his sons? The problem with saying that that is the critical question in the Menendez trial is that it's wrong. The jury never, in any of the two juries, had to resolve the question of whether the Menendez brothers were sexually molested. In fact, the counsel, Leslie Abrahamson, 30 years before, during these trials, properly framed where sexual abuse comes into play. What she said back then is that we have never said that because you're abused, you're justified in killing your abuser. We didn't argue that, and we never will.
After getting into this video, I realized it's over 15 minutes long, so I'm going to play a small portion of it, and you can watch the rest on the DA's website.
Of the 1989 brutal murder by the Menendez brothers of their father, Jose Menendez, and their mother, Kitty Menendez, has come back to the courts in May of 2023. Now, this case is on 3 different tracks. One track involving a habeas petition to get a new trial based on new evidence. A second track involving a petition for clemency directly with the governor of California to get released immediately. And a third track involving a resentencing to get released or put on parole by having the court change their sentence from life without the possibility of parole to life with the possibility of parole. Given the widespread interest in this case by the media and the public, I thought that this case could be a useful portal to understanding how the criminal justice system more generally works. By delving into the anatomy of the Menendez case, we will be able to see how we go from the murder to the investigation, to the charges, to the trials, to the sentencing, to the appeals, to the present-day petitions and motions. The anatomy of the Menendez case starts with the horrific murders that occurred at around 10 p.m. on August 20th, 1989, in the Menendez's Beverly Hills home. Jose Menendez and his wife, Kitty Menendez, while they sat in their den watching TV, were violently shotgunned to death by their own sons. The murderers shot them over 12 times, including a shotgun blast to the back of Jose's head, blast to his kneecaps after he was dead, and a point-blank blast to Kitty's face while she lay on the floor moaning in agony. Officers described the crime scene as one of the most horrific murder scenes they had ever encountered. As soon as the officers arrived, the investigation began. The officers discovered that all the shotgun shells had been picked up by the murderers after the shooting. They spoke with Erik and Lyle Menendez, who had called 911 screaming that someone had shot their parents, and then later claimed to the police and others that the murders were a mafia hit. These investigators followed these leads and others until evidence started to emerge that the killers were the Menendez brothers themselves. At that point, in March of 1990, officers arrested the Menendez brothers for murdering their parents. The district attorney's office reviewed the evidence and decided to file charges against the Menendez brothers for conspiring to murder their parents, for the murder of each of their parents, and special circumstances allegations. Now, the document they filed is a felony complaint. That document itself is not evidence, but it is based on probable cause to believe the Menendezes committed the crimes charged. Once arrested and the charges are filed, the Menendezes are then brought to court where they have a lawyer and the charges are explained. This is the arraignment on those charges. At that point, the Menendez brothers are given a choice. They can plead guilty or not guilty. If they plead guilty, there will be no trial, and the next step would be their sentencing. If they plead not guilty, as they did, the decision as to what happens next returns to the district attorney's office. The district attorney can choose to have the case proceed to a preliminary hearing or can present the case to a grand jury for possible indictment. Now, if the case goes to a preliminary hearing, then the district attorney would present evidence to the court to prove the charges by probable cause.
At this stage, the prosecution does not have to prove the charges beyond a reasonable doubt like it would have to at a jury trial. A preliminary hearing works as a check in the system to make sure the prosecution has at least probable cause at this point to proceed to a jury trial.